SJC-11393, Michael Bakwin versus Robert M. Mardirosian et al.
Yes, counsel, good morning.
Good morning, and may it please the court, Tom Carey for Michael Bakwin with my colleague Michael Calora. This is an appeal that presents several issues regarding the Fraudulent Transfer Act and its available remedies. The act was adopted in 1996, and there are two features that are quite clear. The transferee does not have to share the fraudulent intent of the transferor. So long as the transferee does not exchange substantially equal value, then the transferee is subject to all of the remedies provided in the Act. And the Act, 1996, replacing an act first promulgated in 1918, explicitly provides for a money judgment against the transferee. 1918, we still had separate courts of law and equity. By 96, we know that's over, and there was no real need to limit the kinds of remedies provided in the Transfer Act solely to equitable remedies.
Mr. Carey, do you agree that the judge had the power to do what he did here?
Partly.
Are you arguing he abused his discretion, not that somehow he didn't have the authority to exercise discretion?
I think we've got a mixed standard of review here. One is your cases are clear that if a judge has discretion but doesn't realize it and acts as a matter of law, then that's not a deferential review. You review as a matter of law. And I suggest that that clearly happened with regard to the House and the issues involving the tenancy by the entirety.
Do you
As
say
to
that
the
because
others,
did you say because he felt that that was governed by case law, and that you're saying that case law was inappropriately used?
Correct.
And you're saying because he used the case law that he was not exercising his discretion because he felt he didn't have it under the case law?
Yes.
But was argument made to him that he did have discretion?
Our argument, which was got nowhere, was the statute says you can issue a judgment, a money judgment, judge, that's what we're looking for. He said you can't get that, he has a quote that, even in his opinion, I believe, but certainly in the interchange, that the law is with me on the tenancy by the entireties. With respect to the other aspects of the case, yes, there would be discretion. We don't say that a money judgment is mandatory, shall. But in exercising that discretion, the statute says ordinarily you use the value as of the date of the transfer. And then there's a clause, subject to whatever equities are in place. That's usually talking about such things as the transferee substantially improved the property, put hundreds of thousands of dollars of money into it, and should get credit for that. It also deals with the problem of dissipation. The transferee takes a lot of the money out of the asset. Well, you're not supposed to do that. With regard to...
Well, what if the asset just diminishes in value? Wouldn't that be a circumstance in which equity would require an adjustment?
Not if your starting point is that ordinarily you use the value at the time of transfer.
Let's assume there's $500,000 in a stock account, and the market does Dixie, which it has done before, and it
Yes.
becomes $250,000. Let's say they each had $250,000 ownership in that, and the market is just plummeted. Do you think the judgment should be for $250,000 or for half of what remains?
I believe the statute says it should be for the $250,000.
Unless
That you're
equity-
playing with the creditors, the money that should belong to the creditor, that was fraudulently transferred to you and you paid nothing for it. If you're going to go out and play the ponies, dissipate it in restaurant investments,
But I thought it
or
was in-
put it in some risky investment and it goes downhill, that should be
Well, everything went
at
downhill.
your risk.
Everything went downhill during a certain period of time, regardless of
Yes,
what.
yes.
But say you didn't move it at all. You just didn't, that's where it was when you started, and that's where it is when you get the judgment. So it hasn't moved one bit, but it has plummeted in value to half its value where you started.
That's partly involved in this case with respect to the Citizens Investment Services account.
Well, No, I'm sorry, go ahead.
That account, when it was transferred initially to the wife, had $268,000. Shortly after we attached the other bank account and they learned that we were sniffing around Citizens Bank, within a week, that got transferred to a newly created family trust with the son-in-law as the trustee. Both Robert and the wife were involved in getting the money over there. At that point, the account, nothing had been done with it, and it had gone up. So his half on that date was worth $342. We suggested maybe we should get the $342 for that transaction because of the timing. Thereafter, two things happen. They take $100,000 out, and the market goes down. By the time we got an attachment on the Citizens account, the account itself was down in value to $365, something like that.
In total.
In total. And the judge said, you can get the $268 subject to market fluctuations. I'm not sure what this subject to fluctuations mean. It seems to me that if you want to take the first date, it's the $268, we should get that.
Yeah.
And there's enough there to pay it. If you want to take the second, the $342, there's enough to pay that. But to say that the market movement, the risk is on the creditor, who has no control over how the money that should be available is being handled, we don't think is true to the purpose of the act.
Yeah, you started your argument by pointing to one of the principles of the act, that the transferee need not share the intent of the transferor. But isn't there something implicit in the act that imputes a certain kind of knowledge to the transferee when he's paying nothing? He's not giving fair value.
Oh, yeah, he's on the hook.
Yeah.
The only way he gets off the hook is if he comes forward as an affirmative defense and establishes, I acted in good faith and I gave substantially equal value. That defense is there. But the old law where kind of involvement in the actual intent had to be proved is gone. All you have to show is that the transferor had the intent, which was obvious here and isn't even appealed. I think the interesting part of the tendency
With regard to the 342,
yes.
do you agree that that was not a fraudulent conveyance, the one from Madeline to the trust?
I think it could have been found to be a fraudulent conveyance.
Did the jury make a finding that it was a fraudulent conveyance? I know they found that the
No,
trust
they
was a successor.
No, that's correct. They made a finding that the transfer had taken place, and that was the dollar amount.
So the only fraudulent transfer was the 286? 268.
Yeah, the 68s and 86s in this thing have been driving me crazy. The 268, yes. However, the statute provides that the subsequent transferee is likewise liable. And under the circumstances of that subsequent transfer, we suggested that the court could grant the uptick as part of the
Right, but,
adjustment.
but, I mean, is your argument that if it's more, you get it, and if it's less, you get the amount at the time of the transfer? I mean, it seems as if the comment certainly to the Uniform Act says that essentially the standard is, with some exceptions for equity, that it's at the value of the time of the transfer, and basically the risk of it going up or down is borne by the transferee. Why would that not be the presumed rule?
I think it is the presumed rule.
And when would equities dictate some variation from that?
The examples that are usually cited with respect to that clause are the ones I mentioned. Somebody withdraws funds, the Rhode Island case where they take $196,000 out. No, that's gonna, we're not gonna say you got to put that back in. It's when the transferee does something to improve the property. So it's as though if it were a reach and apply and you were taking the property back, you would have to give them a credit. Likewise here, he'd get a credit for an improvement. So the standard, the basic standard is very clear. Ordinarily, you get the amount on the data transfer.
You're saying market fluctuations up or down are not the stuff that equity should deal with?
Not ordinarily, correct, unless there's something unique going on. That's the way the statute reads.
And is there anything unique going on here?
It doesn't appear to be, other than, I mean, they were withdrawing money.
So
The remedy about we're going to get part of what's in that investment account troubles us, since we know some of the money went out. We don't object to the 268. We would have liked the 342, but we don't object to the 268 on this rationale. We do object to the thought that somehow all of the inner fluctuations are going to be calculated, and our 268, or that half of it, is going to be downgraded, which appears to be what would happen, since we know there's only 365 in there.
Well, let me just explore one point with you on the fluctuation based on market forces.
Yes.
If the asset that we're talking about it appears to the transferee to be something that is going to lose some value pretty quickly, and he changes the species of the asset, perhaps converts it to a different stock, and then the new stock goes up in value. He's applied a certain specialized knowledge. Does he get the credit for that, the transferee?
I suppose you could wonder whether he
Like it's an
gets credit for
improvement.
that, and whether the creditor should get credit for having given him the capital to use to get that fine
Well, but you would be
increase.
satisfied in that example with the 268.
Just to get your money back.
The statute says ordinarily the amount is the value. And they do that because that's a fairly clear value to shoot at, rather than a whole bunch of fluctuating values, yes.
You wanted to get back to the house.
I think we should, since it's the biggest asset, and I think in some ways it's the most interesting legal issue in the case. This was a voluntary deed out by both the husband and the wife, to the wife alone, after the news had gotten out about all his troubles. The court, so at that point, there's no question under the tenancy statute that she's the sole owner of that property. She could, for example, write out a will leaving it to the children, thus avoiding any chance that any judgment against the husband could be satisfied out of the house.
But if, why, by returning it to the tenancy by entirety, you're not any worse off than you would be if the transfer hadn't been made, correct?
It depends on your point of view. It's a bit of a chicken and an egg problem. At the time of the attachment, in the old view, where all you could do is get the property and return it, oh, well, this is the status quo, you're okay. That was the rationale. You're no worse off.
Well, it's just that tenancy by the entirety is sort of special, because you wouldn't have been able to get the asset anymore.
Right,
You would have had the same problem.
right. But it's not us who are breaking this, and it's not him alone who is breaking this. There was a joint transfer that put it in her name alone. Under the modern statute, they both have control of the property legally, ownership legally. It's not like the old days where he controlled everything and did all of these things. Under these circumstances, to deny the judgment for the half interest of the property, valued as of the date that they transferred it, is to effectively use the powers of a court of equity to change the existing status quo, return it to a status quo, thus giving the malfeasor, the husband who was defrauding his creditors, the benefit of a legal second chance. So what's the policy reason that prevents everybody from running out and deeding out the tenancy by the entirety property? If I get away with it, I'm free and clear. If I don't, they just give it back to me, and I'm happy. Bankruptcy courts don't allow that, and your policies should not allow that.
Thank you.
I'm sorry, Madam. Thank you.
Good morning. I am Cynthia Hartman, and I represent all of the appellees in this case who were relief defendants: David Mardirosian, David Barber, Andrea Mardirosian, and Madeline Mardirosian. What the appellee is basically asking the court to do here is to interpret the Fraudulent Transfer Act in such a way as to virtually eliminate the discretion that the trial court has. The equitable principles are mentioned all over the place in the Fraudulent Transfer Act, Section 11, Section 8, Section 9. They all call for adjustments as equity it may require, as the circumstances may require. And that rests a great deal of discretion in the trial judge. And it seems that the appellees are asking the court to take something that really the statute does not say. The statute never says, and now a money judgment can be entered against the relief defendants personally. But they're basically asking you to do that, which would make a transferee, potentially somebody who had no knowledge of any issues at all, no intent.
You're not going to suggest that Mrs. Mardirosian had no knowledge of any of these issues, are you?
Well, Your Honor, there was no evidence that she did. There was no evidence presented by the plaintiff that she did. They did not argue that she did.
And everything's transferred into her name, and she's said, wow, this is great.
Well, Your Honor, the evidence...
Amazing.
The evidence from her partly put forth by the plaintiff in the case was that she had no fault at all. What she testified to was that Mr. Mardirosian had always handled all the finances. This was an elderly lady, sort of an old-fashioned marriage. He had handled all of that stuff, and then these difficulties came down. She had no knowledge of anything that was going on. There was evidence that he had accounts out of the country and so on and so forth, and there was never any evidence that she had any knowledge or involvement in any of that. And the plaintiff was actually very deferential to her and to the other relief defendants in the trial, which I took to be a strategy because they did not want the jury to impose some sympathy upon those relief defendants and possibly not find in favor of the plaintiff on those counts.
But isn't that in part because the statute doesn't require that a fraudulent intent be shown?
Well, the statute doesn't require that fraudulent intent by the transferee be shown.
It wasn't part of their burden of proof to show that they had a fraudulent intent.
That's true. It wasn't their part of their burden of proof to show that Robert Mardirosian fraudulently transferred the assets. But when it came to the fashioning of the judgment, which throughout this trial was always understood was going to be in the judge's province, and remember the judge heard all of this evidence as well, when it came to the fashioning of the judgment, all of those other issues that are raised in the Fraudulent Transfer Act regarding the equitable principles, fashioning a judgment so as the circumstances may require, came into play. And in that case, in the case of Mrs. Mardirosian, for instance, regarding the house, you've heard a lot about from the appellants about how she also executed a deed out of the tenancy by the entirety to herself individually. And it's true, she did, but they did not allege that she had made that fraudulent transfer. They could have, but that wasn't a count. And it wasn't anything that they brought up in trial or tried to prove in trial or even brought up at all until the very, very end of the case during the hearings regarding the judgment when they're asking for a personal money judgment against her.
Let's talk about the brokerage account for a moment. So the jury found that $268,000 was fraudulently transferred from Mr. Mardirosian to your client, right?
Right.
And your client then took $100,000 out.
There was evidence that $100,000 was withdrawn. I'm not sure I'm not sure if there was evidence about who took it out, who did it, or who withdrew it. I believe that transfer was actually after she had transferred it to the MMM Family Trust.
Well,
And
no
it was the
matter.
trustee
It
who
was a
took that
fraudulent
$100,000
transfer
out.
of $268 to her, so that's the corpus here.
Right.
And then she transfers it again to another brokerage firm, and then $100,000 is withdrawn, I assume by her. How
Well-
could their husband, who has no interest in this, withdraw $100,000?
No, again, Your Honor, I'm sorry. I believe that the evidence shows that $100,000 was transferred by David Barber, the trustee of the MMM Trust, after it had been transferred to the trust by Mrs. Mardirosian about a year
Where
later.
did that money go?
I do not know, Your Honor. I can make a guess.
And
The-
David
the
Barber
record
is
doesn't
one of the
show.
defendants here.
The
the
record doesn't
restaurant?
show. I'm sorry?
Did it go to the restaurant?
I'm not sure, Your Honor. My own guess would be that Robert Mardirosian had a lot of legal trouble at the time and had major attorney's fees.
Well,
But
why
I do
shouldn't the
not know that, and it was
why
not in
shouldn't
the
the
record.
$268,000 be awarded as a personal judgment against your client?
Because that would, well, it is a judgment against her
She
to,
took it, she transferred it, it got dissipated.
well, it didn't all get dissipated, Your Honor. The problem is that the accounts get all mixed up. That investment account already existed. The money was added to it. Same thing with the savings account. It already existed, and some money from that CD that was,
His CD was put into her account.
Well, let me correct something, though, Your Honor, on regarding that CD, because I think this is very, very important. The reply brief mentions, and I believe I had also gone along with this in my brief, that the CD had belonged to Robert solely, and that is not true. And I made the mistake of accepting what the appellant said in their brief rather than double-checking the actual exhibit. The actual exhibits, the CD statements, the bank statements, and that's shown in the appendix on page 2231 and page 2203. There's a series of bank statements. The statements themselves are addressed to Robert singly, but then each statement lists the different accounts that are on that statement. The CD shows that it was owned by both Robert and Madeline, always. The
Well, what
bank
did the
statements
jury
are all
find?
there.
Did the jury find that there was a fraudulent transfer in this amount of 300 and, this is the CD, so we're talking
Right.
about $346,000.
And that is half of the CD. That's why the jury found that number. The entire amount that was transferred out of that CD was 500 and odd thousand.
So
And then there,
the CD, the jury found that he fraudulently transferred $346,000, and with respect to the brokerage account, $268,000.
correct, but some of that money from some of that money that went into the brokerage account was from that CD. So we're talking, to some extent, we're talking about the same money. And I realize it got very complicated, and you need to sort of drill down into the exhibits, the documents, in order to track this. But that's what the judge heard all of this, and the judge did all of that. We had,
But help me, with regard to the judgment, with regard to the Citizens Bank account, not the investment account.
okay,
Well, but this is the Citizens Bank account.
the CD went into the savings
Right.
account,
They say
Some of it.
they get half of what's in the Citizens Bank account.
correct.
That ignores the fact that there was a fraudulent conveyance from the CD. That's what they would have gotten had there been no fraudulent conveyance. How is that appropriate?
The CD belonged half to Madeline anyway, already.
The CD I thought wasn't the CD I thought was in his name.
No, that was the correction I just made a few moments ago. If you look at the exhibits, Appendix 2231, 2203, the CD was in both of their names, Madeline and Robert. It matured on February 6, 2006. It happened to mature right in the middle of all
So,
of this.
and the jury said that half of that was a fraudulent conveyance.
Correct.
Right, and much of that money went into the Citizens Bank account.
And the rest of it, I believe, went into the Citizens Investment Services
Okay,
account.
but the judge's order says that the judgment against Madeline equal to 1/2 of the Citizens Bank account. That's what they would have gotten had there been no fraudulent conveyance.
Right, which is, I submit, the purpose of the Fraudulent Transfer Act. Had there been no conveyance, everything is restored back to the status quo, and that applies to the house and the accounts and everything else, because otherwise you end up taking Madeline's half as well. You end up with a judgment against Robert that effectively allows the plaintiff to recover from his share of those different assets, and the judgment does do that. In addition, you end up with a judgment against Madeline, which would effectively allow the plaintiff to levy on an execution against those assets, against her personally. The result of which is she loses her share of the house, she loses her share of all of the accounts. And that, it gives them more than it gives the plaintiffs more than what they would have possibly been able to recover had there been no transfer. Now, clearly there was misconduct found on the part of Robert regarding those transfers, but not on the part of the transferees.
But so isn't Mr. Carey right then? I mean, it's great for somebody like Robert. He transfers it, maybe he's going to get away with it. If he doesn't, nothing's lost. It's exactly the same as it would be. I mean, why even go through the effort of the trial?
Well, in that case, then why does the statute contain a lot of things about adjusting subject to equity and subject to the circumstances of the case?
But you seem to be arguing that not just equity in this case, that as a general matter, you should never be able to take some money from the non-fraudulent spouse in this case.
I'm not arguing that. What I'm arguing that is in the circumstances of this case, based upon all of the evidence and argument that Judge Muse heard at the trial court level, he properly exercised his discretion and applied the statute and equitable principles and fashioned a judgment that was appropriate in this case. I think that another judge in another case could do something different. Another judge in this case might have done something different. But we have what we have, and Judge Muse did not improperly exercise that discretion based upon what he heard.
On the discretionary point, and let's talk about the House if we could, because I think I heard the argument that the judge did not really view himself as having discretion to do other than what he did, because the case law, as he read it, required, in his view, the result that he reached. So the question is, do we review that decision on just an abuse of discretion basis, or we look to it and say, well, the judge didn't really think he had discretion here, and so we're going to see whether the judge's decision was correct. We'll read those cases too and see whether or not they require the result that the judge reached. And if we decide that they don't, then that was perhaps error on the judge's part. What do you say to
I don't
that?
think it's clear in the record at all, and I certainly didn't take it that way at the time, that the judge thought that he had to do that. What he said, the one statement that he made in the record that counsel referred to earlier was that the law is on my side on this. That was in the context of a discussion that encompassed case law and the statute and so on, and I'm not sure exactly what law, whether it was case law or the statute or whatever, the judge had in mind when he said that. But there was certainly extensive discussion. I think it covers about 100 pages in the appendix between the two hearings about this. What he did was try to shut down the fact that the plaintiff kept trying to make the same argument over and over and over again, and he had made it clear the way he was going to rule on that and wanted to move forward in the argument. And so he said, the law is on my side on this, move on, something along those lines. But I don't think it's clear or true that the judge did not understand what he could have done or what he was able to do under the statute. Certainly the plaintiff was telling him that, arguing that all the way through. He just didn't agree. So I think that you would be reviewing this under an abuse of discretion standard.
Can I ask you the bank account?
Yes.
I'm very confused about this. The bank account, Citizens Bank account, how much money is in there right now?
300 and I can't give you an exact number. My memory is 335,000 or in the mid 300,000s.
Is it fair to say the judge awarded half of that to the defendant?
Yes. The judge, because half of it belonged to Madeline anyway.
But the jury found that $287,000 from the CD had been, of his money, had been transferred into that account, and an additional $60,000 had been, of his money that was in that account, had been transferred to her. So there's $347,000 that's been fraudulently transferred into this account, and he gets half of the existing balance, which is $170,000 maybe?
Your Honor, I think the confusion is that the jury did not find and was not asked to find where that money was transferred to. They found that he transferred that sum of money.
To his wife,
But no, not specifically to this account, because some of it went into that account and some of it went into the investment services account, the brokerage account. So the jury just wasn't asked to sort of take it all the way through and find out where this certain money was. The focus was on the transfer, not the current location of the money. So
Who made the decision where it was going to go?
I believe Mr. Mardirosian did, because the evidence was that Mrs. Mardirosian had no involvement or knowledge about what was going on at the time, so that's where. But I'm not sure if anywhere in the record or anywhere at the trial level you will find that every dollar of that initial CD, of Robert's share of that initial CD, ended up in a certain place. All the judge could do, all he could work with, is what we have now. And we have a savings account that had a certain amount in it. It fluctuated over time. It eventually was attached and frozen, and this is what's in it. And if you find that the plaintiffs are entitled to the entire amount that was originally transferred, then you are taking Mrs. Mardirosian's entire share. And again, in a case where there was...
But it was transferred to her, and it's gone.
Well, some of it was transferred to her. I'm not sure if all of it was transferred to her. There wasn't, again, like I said, every dollar is not accounted for. So you might be assuming that it was transferred to her, but that's not in the evidence.
And that's not what the jury found.
Well, the jury found that he had transferred X amount of dollars, not where it ended up.
Okay.
So, again, and I suppose if the plaintiffs had made an effort to account for that money, it would have resulted in trying to impose some fault onto Mrs. Mardirosian. You know, you had this money and you took it and you spent it on such and such, or you knew that your husband was about to go to jail, or you know, whatever. But that's not in the record. They didn't do that at the trial level, again, because I think they were trying to avoid getting some sympathy for Mrs. Mardirosian. And having made that decision, that strategic decision, and again, the judge heard it too, and he heard all of the evidence and applied it when he exercised his discretion to fashion an appropriate judgment in this case, that it came into play.
If I could ask one question, Chief?
Yes, please.
Comment C, Uniform Act. Why should that not govern here?
That's the comment about the value of the asset at the time it was
Basically, the
transferred?
risk is borne by the transferee.
Because the Massachusetts version of the Uniform Transfer Act also maintained Section 11 from the old Uniform Conveyancing Act about equitable principles applying. And again, if you've got something, as you were pointing out earlier, if you've got something that loses value due to the stock market, which in this case is what happened, other than there was evidence of one transfer made, but it wasn't the entire amount by a long shot. It was sitting in this investment services account in 2008. In 2006, 2007, 2008, everything lost value. And also it was frozen at some point, so nobody could do anything about that. So why should Madeline Mardirosian, again, not found to have any fault at all about this, basically lose her half, because what the plaintiff is asking is that all of the losses be attributed to her half. There's no question, and they've acknowledged throughout, that half of it was hers. So why should all of the losses be attributed to her half and not to Mr. Bakwin's half? If it had gone up, I'm sure they would want to share in that. It went down through no fault of anybody other than the stock market. And, you know, again, we have what we have, but the equitable solution is not to give the plaintiff more than what he would have received had there been no transfer. And I realize that there's a policy consideration regarding discouraging people from making such transfers in the hopes that they're not going to be caught. But the opposite end of that is that you are taking the half that the spouse legitimately was entitled to throughout, the blameless spouse, because there was no evidence that she had any fault. You're taking hers because of what her husband did. And there's nothing in the law that allows for that. In fact, there's an old statute that specifically prohibits that in the case of a spouse. That is not a desirable result. It is not what the Fraudulent Transfer Act contemplates.
Thank you.
Thank you.
I have leave on a 16L letter.
Yes, and of course, she can respond to your 16L letter.
Thank you.
Thank you.
And if I might give you one-page record cite A.
You can include, why don't you include that in your letter? Thank you.